Nagarajana from the Central University of Kerala to present right to privacy, need for a legislation with special focus on personal data protection bill.
Afternoon, everyone, respected dignitaries and my dear friends. So, first of all, I would like to invite your kind attention some of the issues that have reported in the newspaper very recently. So, one such is the hijab role. So, we know that in Karnataka, a few months back, certain Muslim girls they were denied their right to access to education, and they were punished for wearing hijab to college. These are all the violation of their fundamental right. Another issue was with regard to the cybersecurity. There was a survey called the Responsible Digital Citizenship and Online Safety, which was conducted by the Disney Star India along with a startup which focuses on the online safety of children. So as per this report, about 70% of the children, they were worried about their online safety and privacy. This is quite really a shocking news. Then moving on to a conflict with regard to the Aadhaar Act 2016. So there was a provision that the Unique Identification Authority of India, they cannot share the details or Aadhaar details specifically of an individual such as four biometric information to an investigating agency to match the chance prints or the photographs from the crime scenes. So the explanation given by the Unique Identification Authority of India is that the object of the Aadhaar Act is to empower people with a unique identification and to build a digital platform which is only for the purpose of this identity proof. And there were issues like Pegasus, which was reported in news regarding the leakage of the information from the personal devices of the individual who is in the dignified position. And then there was a news with regard to the withdrawal of the personal data protection bill. So all these matters in one or the other way, it talks about right to privacy. So my topic is the right to privacy, need for a legislation with special focus on personal data protection bill. So the Supreme Court has asserted that Article 21 is the part of the fundamental right. It has proved to be multidimensional, and the extension to the dimension of Article 21 has been made possible by giving an extended meaning to the word life and liberty, and these words are not to be read narrowly. Then Article 21, it is a containing term called procedure established by the law. So this was mentioned in a very famous case called A.K. Gopalan versus State of Madras in 1950, where the Supreme Court has taken the narrow interpretation of Article 21. But this judgment in A.K. Gopalan's case was overruled by the Maneka Gandhi versus Union of India. And there the Supreme Court has taken a wider interpretation of Article 21 and it introduced a term called due process of law. So this is how the Article 21 is said to contain wider aspects. Then what is this right to privacy? Right to privacy is a specific right of an individual to control the collection, use and use of the personal information. So this personal information could be in the form of personal interest, habits and activities, family and educational records, communication including mails and telephone records, then financial records, medical records, etc. So right to privacy means right to personal autonomy or right of a person or a person's property to be free from the public scrutiny or exposure. Then the question is how this right to privacy became a fundamental right. So it is the judicial activism which has brought the right to privacy within the realm of fundamental right by interpreting Article 21. So there the judiciary recognized this right to privacy as an integral part of this right to life and personal liberty. Then let's look into the legal background of the evolution of right to privacy as a fundamental right. So in MP Justice Takesh Chandra, there it was the first judgment of the Supreme Court relating to right to privacy in India. Then the Supreme Court recognized this right to privacy for the first time in Tharak Singh versus State of UP, and that recognition it became more stronger in Govind versus State of Madhya Pradesh. Then right to privacy was declared as a fundamental right in Justice K.S. Puttaswamy versus Union of India. So there, in 2012, Justice K.S. Puttaswamy, the retired judge of the Karnataka High Court, he filed a writ petition before the Supreme Court challenging the constitutional validity of the Aadhaar scheme introduced by the UPA government. So in 2015, a bench of 3 judges they passed an order that a bench of appropriate strength must examine the correctness of decision in MP Sharma versus Satish Chandra and Bharat Singh versus State of UP. Then accordingly, this matter was placed before a 5-judge bench, and subsequently it referred to a 9-judge bench of the Supreme Court. The 9-judge bench of the Supreme Court unanimously passed a landmark decision in 2017, upholding the fundamental right to privacy under Article 21 of the Constitution. Now let's move on to the second part, that is the Personal Data Protection Bill. And this Personal Data Protection Bill, it introduced in the Lok Sabha by the Minister of Electronics and Information Technology on 11th December 2019. So this bill, it seeks to provide protection to the personal data of the individual and to establish the Data Protection Authority. And this bill, it governs the processing of the personal data by the government, the company incorporated in India, the foreign company which deals with the personal data of the individual in India. And this bill, it categorizes the personal data, certain personal data as sensitive personal data. So this personal data, it is said to be a data pertains to the characteristics, attributes, or identity relating to the individual. And this, as per the provisions, there will be a fiduciary agency, and they will check the processing of the personal data, and so that they should be more transparent and accountable. So this bill, it was amended 81 times, 12 recommendations were made to this bill. And in 2020, this bill placed before the Joint Parliamentary Committee, but finally, the bill has been withdrawn by the government in the year 2022. So the major drawbacks of this act was, as I have said, it was amended 81 times. It faced too many amendments. It's too compliance intensive. So there was provision regarding data localization, which was not specific, and there was it faced major pushbacks from the stakeholders, various stakeholders, and it allowed the central government agencies a blanket exemption from adhering to all or any of the provisions of the bill. So, since there is no legislation with regard to the data protection and privacy together, we need to focus on the way forward. So, while drafting a new bill, the government should focus certain areas, like the data should be stored in regions trusted by the central government. The new bill should do away with the simplification of the data in the perspective of data localization, and it should contain certain provision providing damage to the individual personal data has been compromised by any entity. So, still the question it arises: why do we need a legislation? So, in India, the only legislation that deals with the data protection is Information Technology Act 2000, and that too, it is an outdated one. So this Information Technology Act, it deals with how this businesses, they use the personal data of the individual, and the rules have barely been enforced. So in order to avoid this situation, there should be a legislation. So India lacks a legislation for data protection because all the social and economic activities are placed in online. As the technology advances, there is a need for such kind of data protection legislation, because the threat to privacy is increasing more and more. So as a concluding note, I would like to say that the country like India, we should focuses more on this right to privacy aspect, because the country India, it stands in the second position in terms of the population index, and it is being in the 46th position in terms of the global innovation index. It should be more careful about the protection of the privacy, because the privacy aspect is wider in magnitude. That's all about my topic. Thank you.
Okay, next presentation. So you mentioned in your presentation that IT Act 2000 is an outdated legislation.
So, as I have said, the technology is advancing. There are more provisions, like even in the Personal Data Protection Bill, there were provisions like data localization and the rights of the individual relating to their personal data. and how this personal data can be transferred to a place outside India. So it contained all these provisions, but all such provisions are not there in the IT Act. So it should be either it should be amended, or otherwise we should need a new legislation on this.
Okay. Good. And one more point is in Kokasami case, originally it was placed for a 5-member bench. Am I right? Later on it was.
No, sir. First, it is placed for a 3 judgment. Then they passed an order that it should. Earlier, there were decisions which relating to the right to privacy. So it should be referred to the appropriate strength of the judges.
Not only that, right?
And after that, it placed before 5 judgments, and then it referred to the 9 judgments.
Not because of the inconsistency.
For clarifying or examining the success of the decision, earlier decision.
Not like that. It is called a constitutional issue. A constitutional issue is to be heard by 5 members. Okay. Constitutional bench means you should have near 5 members. The question is, later on it has changed to a 9-member bench. Why? Why not change?
Because the issue involved in was complex, because there were so many cases. So Swami 1, into 2000. So 2017, examination of correctness of the decisions in the earlier cases, along with the provisions of the Aadhaar Act, which the provisions which are contained in the Aadhaar Act. In the later 2019 case, how the Aadhaar Act specifically dealt with how this Aadhaar Act specifically deals with the right to privacy. So it violated the right to privacy.
Is there any international provision involved in it? Human rights provision relating to privacy? Article 12 of the that speaks about this. Right. Good place.
No, nice presentation. My doubt is that to what extent this protection of personal data practical technology is developed, hacking provisions are so many technical issues are there. They are not sure of data is.
Yes, sir. I would like to quote an example that we are all familiar with the Pegasus issue. So there, what happened is that the software it entered into the device of a person without touching a single link. So it can enter into the personal device unknowingly by the person. So it is more complex and technical matter. So the technical experts should be.
They are not sure. Okay. Thank you.